A British protected person is a member of class of certain persons under the British Nationality Act 1981 associated with former protected states, protectorates, mandated and trust territories whose external affairs and defence were under British control. The inhabitants of these former states or territories were never automatically entitled because of the birthplace to become British subjects or citizens, but were given the status of British protected person instead. BPP status is a form of nationality under public international law, but is no longer associated with the right to live anywhere or to enjoy citizenship of the European Union. British protected persons are not Commonwealth citizens in British nationality law. They do not have full civil rights in the United Kingdom. However, BPPs, like Commonwealth citizens and Irish citizens, are not considered aliens in the United Kingdom. History. Certain parts of the British Empire were under British suzerainty or effective control but did not become part of the Crown's dominions. These included protected states, protectorates, mandated and trust territories. As these states were considered to be foreign soil, birth in such a place could not, in general, confer British nationality. Instead, the denizens of these states were conferred with the status of British protected person. Originally, BPP status was conferred on the subjects of the rulers of the protected states, with those rulers determining who were the subjects. Subsequently, a more sophisticated test of belonging was established by royal prerogative under the British Protected Persons Order 1934. BPP status was defined in statute law for the first time by the British Nationality Act 1948. The British Protectorates, Protected States and Protected Persons Order came into force on 28 January 1949, establishing for the first time a statutory basis for British protected person status. The status of statutory BPP was largely replaced that of royal prerogative BPP by the 1949 order. However, some persons may still be granted royal prerogative BPP status if connected to a former protectorate or protected state, with no other nationality and no prospect of obtaining another nationality. BPP status was normally lost automatically upon acquisition of the nationality of the country with which the person was connected. In some cases, any person with BPP status connected to the territory lost BPP status, even if they did not acquire the citizenship of another country when the status of a protectorate or trust territory came to an end. While the majority of BPPs connected with former protectorates or trust territories retained BPP status if they did not acquire the citizenship of another country, BPPs connected with former protected states all lost BPP status. Historically, British protected person status was associated with the following kinds of overseas possessions. Protected states. These were states which enjoyed internal autonomy and commonly had their own nationality law while Britain controlled only defence and external relations. In states with their own nationality law, Britain accorded BPP status on nationals recognised by that law. No one today has statutory BPP status because of the connection with a former protected state. Former British protected states are Bahrain, Brunei, the Maldives, the Malay states, Tonga, Qatar and the Trucial states of Abu Dhabi, Ajman, Dubai, Fujairah, Ras Al Khaimah, Sharjah and Al Kuwain. Protectorates, similar to protected states, but where an internal government was also set up by Britain. In many cases there was little practical distinction between a protectorate and a colony. except for the legal status of its belonging or otherwise to the Crown's dominions. In many instances, Britain provided for the possible retention of the BPP status of Protectorates denizens if they did not acquire the citizenship of the fully independent state. However, this was not always the case, and no provision was made for BPPs from British Somaliland or the Aden Protectorate to retain the status after independence. League of Nations Mandate Territories and United Nations Trust Territories. These were states which the League of Nations and its successor, the United Nations, made Britain responsible. All of the British Trust Territories, except Libya, had previously been Mandate Territories. They were treated as if they were protectorates for nationality purposes. Today only BPPs whose status was acquired from the connection with Tanganyika and British Togoland have the possibility of still having BPP status. Statutory British Protected Persons. Today a person is a statutory BPP if he or she pre-independence by birth was born in one of the former protectorates or trust territories shown in the table to the right, has never become a citizen of the newly formed independent state, and has not acquired any other nationality since the 16th of August 1978. A person born in the British Solomon Islands Protectorate after the 1st of January 1975 only becomes a BPP if he or she would otherwise have been stateless, by male descent, or if his or her father was born in one of the former protectorates or trust territories shown in the table to the right, and he or she was born before 28th of January 1949. Was born outside the former protectorate or trust territory, has never become a citizen of the newly formed independent state, and has never acquired any other nationality before or after independence, has not acquired any other nationality since the 16th of August 1978. By male descent, or if his or her father was born in one of the former protectorates or trust territories shown in the table to the right, and was a BPP at the date of his child's birth, and he or she was born on or after the 28th of January 1949 but before the creation of the newly formed independent state, was born outside the former protectorate or trust territory, has never become a citizen of the newly formed independent state, and has not acquired any other nationality since the 16th of August 1978. A person whose father was born in the British Solomon Islands Protectorate after the 1st of January 1975 only becomes a BPP if he or she would otherwise have been stateless post-independence by male descent, or if his or her father was a BPP by birth on his child's birth, and he or she was born on or after the creation of the newly created independent state but before the 16th of August 1978, has never become a citizen of the newly formed independent state, and has not acquired any other nationality since the 16th of August 1978, by male descent, or if his or her father was a BPP by birth on his child's birth, and he or she was born on or after the 7th of July 1978 but before the 7th of July 1980, and would, if not for possessing BPP status, have been born stateless and remain stateless, by male or female descent and birth within UK and overseas territories post-1982. A person is a BPP if either of his or her parents was a BPP at the date of his or her birth, and he or she was born on or after the 1st of January 1983 in the United Kingdom or its overseas territories, had no other nationality at birth, and has not acquired any other nationality. By registration as a BPP on the basis of descent and residence, a person can apply to be registered as a BPP if either of his or her parents was a BPP at the date of his or her birth, and he or she was born outside the United Kingdom or its overseas territories, has fulfilled the required residence requirement within the United Kingdom or its overseas territories, has never possessed any nationality. Any person so registered would have lost or will lose the BPP status if they ever acquire or had ever acquired any other nationality. By marriage before the 1st of January 1983, the wife or widow of a BPP could apply to be registered as a BPP herself if she has never become a citizen of the newly formed independent state. Her husband was a BPP on the application date, or would have been, if alive on that date. She has not acquired any other nationality since the 16th of August 1978. Solomon Islands. There are two ways individuals would still have BPP status owing to the connection with the Solomon Islands. These are that they had BPP status prior to the independence of the islands and did not gain citizenship of the Solomon Islands or of any other country subsequently, or they were citizens of the United Kingdom and colonies prior to independence solely by reason of the connection with the islands, and did not acquire citizenship of the Solomon Islands or of any other country subsequently. Like in other protectorates, a person born in the Solomon Islands whose father was at the time of his or her birth of CUKC, was deemed to be a CUKC by birth. This had the effect of allowing United Kingdom and colonies citizenship to be maintained indefinitely, in contrast to the normal position of the children of CUKCs born outside Her Majesty's dominions, people whose United Kingdom and colonies citizenship was held solely by the connection with a protectorate normally kept that citizenship if they did not become citizens of the independent state formed on that protectorate's demise. This did not occur in the case of the Solomon Islands. CUKCs who held their citizenship for the connection with the Solomon Islands lost that citizenship but were given BPP status if they would otherwise have been stateless. In common with other Solomon Islands BPPs, the BPP status acquired under this provision is lost if the BPP acquires any other nationality. British nationality and protectorates. Although most people connected with protectorates and protected states did not acquire British subject status, there were some exceptions. Persons born in a protectorate and some protected states with a British subject father were British subjects by birth. This exception to normal rules on transmission of British subject status was put on a statutory basis by Section 2 of the British Nationality and Status of Aliens Act 1943. On the 1st of January 1949, any British subject born in a protectorate or a protected state automatically became a citizen of the UK and colonies under Section 12 of the British Nationality Act 1948. Governors of protectorates and some protected states had the right under Sections 8 and 10 of the British Nationality Act 1948 to register or naturalise persons as citizens of the UK and colonies by virtue of a connection to that protectorate or protected state. Some of these persons may have lost CUKC at independence of the protectorate or protected state concerned. If they retained CUKC, they would generally be British citizens or British overseas citizens. Access to British citizenship. British protected persons may normally become British citizens through one of the following routes: residence in the United Kingdom after 5 years residence in the United Kingdom, and holding indefinite leave to remain or its equivalent for at least 12 months. A BPP may apply for registration as a British citizen under Section 4 of the British Nationality Act 1981. If married to a British citizen, it is possible to apply for naturalization as a British citizen after 3 years residence in the United Kingdom, provided ILR is held on the day of application. Both of these options confer British citizenship otherwise than by descent, and hence children born subsequently outside the United Kingdom will normally have access to British citizenship. Persons otherwise stateless, British protected persons who hold no other citizenship or nationality, and have not lost or renounced any other citizenship or nationality after the 4th of July 2002 may apply to be registered as British citizens. Loss of BPP status. A British protected person who acquires another nationality, voluntarily or otherwise, automatically loses BPP status. BPPs may be deprived of BPP status on terms similar to those applicable to British citizens. A BPP may renounce BPP status on the same basis as a British citizen. However, there is no provision to resume BPP status after renunciation.